To go. Start. This being the position of law, it is clear as cloudless sky that the High Court has totally ignored the criminal antecedents of the accused. What has weighed with the High Court is the doctrine of parity. A history sheeter involved in the nature of crimes which we have reproduced herein above are not minor offences, so that he is not to be retained in custody, but the crimes are of heinous nature, and such crimes by no stretch of imagination can be regarded as jejune. Such cases do create a thunder and lightning having the effect potentiality of torrential rain in an analytical mind. The law expects the judiciary to be alert while admitting these kind of accused persons to be at large, and therefore the emphasis is on exercise of discretion judiciously and not in a whimsical manner. Before parting with the case, we may repeat with profit that it is not an appeal for cancellation of bail, as the cancellation is not sought because of supervening circumstances. The annulment of the order passed by the High Court is sought as many relevant factors have not been taken into consideration, which includes the criminal antecedents of the accused, and that makes the order a deviant one. Therefore, the inevitable result is the lancynation of the impugned order. In Anil Kumar Yadav versus State NCT of Delhi 2018-12 SCC 129, this court, while considering an appeal from an order of cancellation of bail, has spelt out some of the significant considerations of which a court must be mindful in deciding whether to grant bail. In doing so, this court had stated that while it is not possible to prescribe an exhaustive list of considerations which are to guide a court in deciding a bail application, the primary requisite of an order granting bail is that it should result from judicious exercise of the court's discretion. The findings of this court have been extracted as under. While granting bail, the relevant considerations are nature of seriousness of the offence, character of the evidence, and circumstances which are peculiar to the accused, and likelihood of the accused fleeing from justice, the impact that his release may make on the prosecution witnesses, its impact on the society, and likelihood of his tempering. No doubt, this list is not exhaustive. There are no hard and fast rules regarding grant or refusal of bail. Each case has to be considered on its own merits. The matter always calls for judicious exercise of discretion by the court. This court, after referring to a catena of judgments emphasized on the need and importance of assigning reasons for the grant of bail. This court categorically observed that a court granting bail could not obviate its duty to apply its judicial mind and indicate reasons as to why bail has been granted or refused. Stop.